My name is Dave Branfman, and I'm the principal attorney at Branfman Law Group PC, where we specialize in intellectual property law and entertainment law. Our clients really represent almost every kind of industry that you can think of, starting from singers and songwriters all the way up to companies that manufacture aftermarket hot rod parts. And of course, because we're in Southern California, we represent a lot of Southern California companies which have businesses that are unique to Southern California but have worldwide appeal. There are so many different types of intellectual property that can be infringed upon. The most common ones are copyrighted materials, songs, music, things like that, films, patents for inventions, trademarks, which are company names. But the things that people don't really think about are things like voices, likenesses, people's images, sometimes even facts. And now there's even a growing set of cases having to deal with whether or not the design and shape of food as presented by a master chef can be copyrighted. Intellectual property lawsuits do seem to be increasing all the time. I've been watching this trend now for many years, and in large part now, it's because of the growth of the internet. The internet not only makes it easier for people to get into business, legitimate people to get into business, it makes it easier for unscrupulous people to get into the business of stealing intellectual property assets from legitimate businesses. In the old days, let's say up until about 10 or 15 years ago, the typical CGL policy included a pretty broad range of coverage for advertising injury, which would cover things like claims for copyright infringement and trademark infringement. Now, in the last 10 years or so, we've seen the newer policies are being much more restrictive and really cutting back on the breadth and scope of the claims that will be covered by the average CGL policy that a business buys off the shelf. And so we're recommending that our clients go out of their way to make sure that they get the additional coverage, either by getting an additional endorsement or a rider from their insurance company to make sure that they're gonna be covered in the event that they're sued or threatened with a lawsuit for copyright infringement or trademark infringement or anything like that. There's a range of questions that I think insurance agents should ask to try to uncover their client's IP exposure. And in fact, I would recommend developing a checklist so that it's not left to the agent's memory to decide what questions to ask. But the questions can fall into a broad range of categories, such as do you use a trademark to identify your name or business? And if so, has that trademark been searched and cleared so that you know you own that trademark? If you're using any kind of advertising materials that include any photographs or anybody's image, have those images and have those photographs been cleared? If you're using computers in your business, and who isn't these days? Has all the software been properly licensed? I mean, there are just a host of questions that need to be asked if the goal is to reduce risk as much as possible. I think that there could be a boom industry for the insurance industry in helping their clients obtain insurance, not just to protect the business from being sued for copyright infringement or trademark infringement, but also helping that business obtain insurance so that if that business needs to sue somebody else for infringing their copyright, they're going to be covered for the cost or 3/4 of the cost of having to go after the infringer. That's called plaintiff's abatement insurance, and most businesses don't know to ask for that, and there aren't that many insurance companies, at least not that I'm aware of, that are out there selling that type of insurance. And if I'm right about that, I think this could be a whole new market segment that the industry hasn't really thought about all that much.